Calls case People versus Donnelly.
Let's get this one's already signed.
Sam Bernstein with and on behalf of Donnelly 1332.
Assistant Public Defender Natalie Pate with and on behalf of the other matter.
State your name.
Donnelly.
Thank you, sir. All right.
And in 1332, I am asking to set this for exam, Your Honor.
We are making the same request, Your Honor, to our understanding discovery is complete.
Is that correct, Mr. Brinkley?
Yes, likewise, Your Honor. Yes.
There's no objection to these being on the same date.
Natalie's okay with it. I'm fine.
No objection, Your Honor.
All right. People, other witnesses available on the 8th. All right. Preliminary examination in both of these matters in person, October 8th, 2024, 9 a.m. in person before Judge Berg on both of these matters.
Judge, I'd like to address bond.
Yes, you may. Go ahead.
Judge, we had originally asked for $100,000 on the resisting instructing case in the lien and $25,000 on the UTA. He has a lengthy criminal history. The issue here is that he had open warrants at the time that he fled from the police. He caused injury to one of the officers when he picked up the chest when he ran after him. The UTA was with a victim who had a PPO against him, and he was just charged last night for another fleeing case where he fled from the cops, got in a car wreck, injured the victim that he had that should PPO out against him. He broke her femur and kneecap and foot as a result of the car crash. So that warrant just got processed. So we're himself in that warrant. So that's on to at least $100,000, which we originally asked for. He's out at a PR bond right now. I believe he's a danger to the community based on the fleeings, the RNOs, and the fact that there was a PPO with this victim and he continues to have contact with her.
Your Honor, he is denying that there was any car crash last night. So
it wasn't last night. I'm sorry. I wasn't saying it was last night. The warrant just got issued on it because they just sent the police report and everything on it.
Okay, well,
So, before you respond, so when did it occur or allegedly occur?
I believe the beginning of September. So that had happened, and then this had happened. And originally we had asked for $100,000 on this case and $25,000 on the UTA too.
Well, okay, I want to be clear on what you're telling me. The new incident that you're talking about occurred on the beginning of September.
September 2nd, correct.
All right. And then I have these incidents occurring, well, one of them occurring on September 17th. So that's the one that you're talking about that at the time of, that's on case, I think, ending in 1261. At the time of that offense, there was this other offense that was out there allegedly that involved Mr. Lee.
Correct. And also a UTA the UTA that you have before you now that happened back in April to July, around that time period. That UTA, he had an outstanding warrant for that when he fled from the police on the one on the 17th. That's the most recent case, the one on the 17th with the RNO and him fleeing from police at that time.
Okay.
He had an open warrant out for the UTA. Then he gets the fleeing elude with the police, runs from the police, injures a police officer. And then before that, on September 2nd, he had fled from the police, injured the victim in the case, in the UTA case. So there's a lot going on, and I believe that him having a PR bond, plus based on past criminal history, I believe he should have some type of monetary component.
Either of you?
We would ask bond to stay where it is. To our understanding, it sounds like he didn't allegedly commit any of these offenses while on bond. They're all allegations at this point. He did show up here today and he will be in attendance for all his future court dates. To my understanding, he is compliant with bond thus far. He's taking this matter very seriously, staying in contact with both counsel. We would ask bond to stay where it is.
and I think piggybacking off that, if there's a new warrant sworn out, he'll appear in front of a magistrate for that when it's right for him to do so, and bond will be set as appropriate in that amount. For the UDAA case, it's not a crime of violence or anything like that. It's just the use of a car. And the complainant emailed the magistrate, said, it's not a big deal. I gave him permission to use the car. I just want the car back right now. We're incurring impound fees. For that case alone, Your Honor, I would ask bond to remain the same. That's appropriate.
I guess the only concern that the court has is that there's allegedly this other event at the beginning of September that occurs allegedly that would not have been taken into account by the magistrate at the time of the setting of the bond in at least the second case.
And it's hard for us to address that, Your Honor, because we're just finding about this right now. I haven't read anything.
I got you. I appreciate that. And I think to fully address bond, given the concerns that are raised by the people, is there a police report that is part of that case?
You went from September 2nd?
Yes.
Yes.
All right. So here's what I'm going to do. All right. And Mr. Lee, I've not made a decision on it because this is all coming to me.
Yeah, this is new to me.
Okay. All right. So what I'm going to do is I'm going to pass the matter. I want counsel to look at the police report, go through that with Mr. Lee. Mr. Lee, do not leave the courthouse. Okay. Because I'm not, normally what I would do in this case is I would put you in back, let them talk to you. Do not, okay. Just don't do it. Because you know how I am. So I got to send somebody to get you. All right. So we'll just leave it that way. And then they'll get the report, go through it. Now, I'm just going to tell you that I may change your bond. I may not. They've got to look at it, but I want them to make an argument. I want you to know what they're talking about, and then we'll see. Okay?
Right.
Fair enough?
Thank you.
All right.
Yep. Okay. Go. Will you hand me my screen box?
Now go.
Recalls cases of the people versus Dunley.
That's the punishment that people.
Public Defender Natalie Tate with on behalf of Mr. Lee, the case ending in 1261.
Good morning, Your Honor. Sam Bernstein on the other case with on behalf of Mr. Lee, who is present.
All right. Okay. Where are we? You got a chance to review the report.
Yes, we have, Your Honor. And in the police report for my case, it does reference a prior incident. That being said, we frankly, I don't personally know what the magistrate knew at the time of setting the bond in this case. I don't know if she was aware of the prior September incident that was prior to this alleged offense. Sorry, Your Honor. That being said, we would ask the bond to remain the same. Mr. Lee has, of course, showed up here today. He does reside with his mother in Ypsilanti and also has full-time work as a contractor with Handy Helpers. And we would ask that bond remain the same. He will be returning to court, remaining in compliance with bond. They're all just allegations at this point. And when that warrant is authorized, or maybe it is already authorized, he will be arraigned on it and bond will be set in that matter. We ask that bond remain the same on these cases.
That's a lot of what I was going to say, Your Honor. In reviewing the report, it does seem that the matter brought up today is referenced in the report. That's the subject matter of Ms. Pate's case. So I don't know that the magistrate was unaware of it when making her bond decision. So it's hard to say that she abused her discretion, not knowing whether she was aware of it or not. I think
certainly wouldn't have been aware of it to the point that it resulted in charges.
Right, in charges, I don't think he's charged with it right now either. So, but I think in the normal.
I just charged it. So
that's what I thought she said.
Right now, they're going to just swear to the warrant, but it's charged. It's been issued. I wrote it last night and I signed it this morning. The only thing that was on the bond form, because I'd written the original bond form, was that he had outstanding felony warrants. Officers were trying to pull over Deep when he fled from them. He then got out of the car and ran on foot. He fell and kicked Deputy Gamos, causing injury. Defendant has extremely lengthy criminal history, full of assaults. There have been 11 DUI incidents between the defendant and the victims since 2020. And that is all that we have had on our bond forms. So I mean.
So Your Honor,
it is concerning that he keeps fleeing from the police, and now that fleeing the point that now other people are being injured. his history is terrible, Judge, and he just keeps causing havoc in the community, especially on this victim. So I'm surprised he had a personal bond to begin with, to be honest, even without this other allegation.
Anything you were going to say?
Yes, Your Honor. Mr. Lee did not know that there was a warrant pending. People don't often get letters in the mail saying, hey, there's a warrant pending. They don't find out that way. So whether there was a warrant pending or not, I mean, he doesn't know about it. I mean, he may be charged, but it's not at the point where he can come to court on it yet. And in the natural course of events, he will be at that point.
Well,
And
what do you mean he can't come to court on it? Here's my issue. My issue is, and I think I was explaining this to Mr. Lee before I passed it, is looking at that other case, were those other activities, I don't think Mr. Lee was clear, and I don't think counsel was clear that of these other activities early part of September. So I wanted you to take a look at that. The problem is that now there are new charges that are pending. That's part of the problem now. All right.
And I think a lot of the request now is to raise his bonds in the current case, Your Honor, and not just set a bond in the new case. So if there's going to be a bond set in the new case upon the time of arraignment, I mean, that is what it is, and that's in the natural course of events. But at the same time, raising his bonds in the other cases that are already there isn't something that needs to be done, Your Honor.
Well, it does, maybe.
Well, like, we'd appreciate a nominal bond if he's stuck in there, but raising his other bonds to $100,000.
When is the other matter going to be sworn out? Do we know?
I would hope today, Judge. I'll contact them, make sure that they usually send out everything today, since I heard this morning.
Okay. Anything else from my side?
I think it's clear that Mr. Lee does come to court. He sat there for an hour. He knows, been in front of Your Honor before. He can guess what might be coming. He had an opportunity to leave if he wanted to, and he did not. So Your Honor knows that he will come to court. He will face whatever music there is. And if he's told to come in court in the future, he's going to do that as well.
Yeah, but my concern is whether or not he's going to flee from police again. Because there's two incidences now. He had open warrants when he fled from the police at the one time. He caused injury to that officer, caused injury to a civilian. So that is my issue. I'm glad he's in court today, but once he gets outside of these court doors, whether or not he's going to flee from police again or hurt another individual, hurt a random person in the roadway, that is my concern.
And there's a full range of options at community corrections, Your Honor, with testing, tethers, keep them at home, et cetera, that can be put in place.
Here's what I'm going to do in these cases. You're set. Problem is, you're set in a few days before Judge Burke on the 8th. There's going to be another one coming down the pipe, Mr. Lee.
I'll be there.
Well, I'm going to, and I told you I might do this. I'm going to change your bond on these cases. I'm not going to go as high as they want me to go, but I'm going to change your bond given everything on these cases. There'll be the opportunity since, so that you kind of follow what I'm doing. On the 8th, when you're before Judge Burke, after all the testimony and everything, to argue for a reduction on those cases. I'll let the other case kind of follow its normal course to what's going to happen in terms of arraignment on that. All right. You follow me? I know you're staring at me, but what?
I'm kind of confused because I don't understand how can they charge me with something today that hasn't been charged with me yet, and I haven't.
Hasn't. Say that second part again. I didn't.
They charged me with something that I wasn't even charged with when I went to court, and I don't understand that. And it's popping up today. It's been.
Well, the charges are today. My understanding, I don't know when the report came down or whatever. That's why I passed it the first time, because I wanted everybody to be able to take a.
Yeah, I understand it, but they charged me with something that had no neglection stuff, and that's not fair.
That what? I didn't hear that.
That had no neglection of, and that's not fair to me.
Well, I don't know if it's not fair to you, but it would be nice if kind of, I think your major point is if everything happened in order, it'd be a lot easier to kind of follow. And that's, I get your point.
Well, tell her something.
What I'm going to do in each of these cases, because I also don't know about the injuries that occurred.
Well, can I get a GPS or something?
Well, here's what I'm going to do. And I'm going to raise your bonds in these cases to not as high as the people want, because I'm taking into account that Mr. Lee has appeared. There are times where Mr. Lee doesn't appear, but Mr. Lee has a reason when he doesn't appear before me as to why he wasn't here. He will appear. I don't have a problem with that. I've never had a problem necessarily with Mr. Lee. So what I'm going to do is I'm going to raise your bond to $15,000 cash surety in each case. I will let counsel, hold on. Okay, Mr. Lee. Counsel, you can let Judge Burke know that I'm also, and he has certainly that discretion, that it's because of things I don't know regarding these cases that he may hear once the preliminary exam goes forth. So for whatever that's worth, he can take that into account. But we'll do that. And then the other case, I'm going to ask the people to do everything, just in fairness to Mr. Lee, because of what he's saying in terms of the order of things, to get that other case expedited so it can get to us so that we can take a look at everything that's there. And they're not just allegations that are outstanding, but we can deal with something concrete. Okay. So on these bonds, as they're changed, defendant is remanded to the jail.
Thank you. And I did contact Schaefer to have him swear to it today, Jim.
Thank you. Court calls case People versus Don Lee.
Conrad Siller on behalf of Pittsfield Township.
Assistant Public Defender Natalie Pate on behalf of Mr. Lee, who stands to my right. Please state your name for the record, sir.
Don Lee.
All right. Okay, where are we on this case?
Thank you, Your Honor. This is a driver's license case and I have discussed this with Mr. Lee. He will be accepting the offer extended to plead to MCL 257.326.
So, Your Honor, I'd move to add count 2 of MCL 257.326, allowing an ineligible person to drive. You accept that guilty plea to add count 2. I move to dismiss count 1.
This court's understanding you're going to plead guilty to the charge of allowing an ineligible driver to operate a motor vehicle. That's a misdemeanor, punishable by up to 90 days, $100 fine plus court costs. You understand that, sir?
Yes, sir.
And understanding all that, still wish to plead guilty?
Yes.
And to that charge, how do you plead?
Guilty.
And you understand by pleading guilty, you'll not have a trial of any kind. But
Yes.
you cited an advice of rights form, correct?
Yes.
Any question regarding those rights?
No.
Look at paragraph 5. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes.
You understand you're giving up your right to appeal of right?
Yes.
Are you on probation or parole?
No.
Anybody promise you anything other than what's stated here today on the record to get you to plea? Anybody threaten you or coerce you?
No.
Doing this voluntarily
Yes.
of your own free will because you believe that you are indeed guilty?
Yes.
On the date of February 10th, 2024, Michigan Road near Moon Road in Pittsfield Township, Washington County, State of Michigan. Did you have custody or control of a motor vehicle?
Yes.
Did you allow someone who is otherwise ineligible to operate that motor vehicle?
Yes.
Counsel, have I complied with the court rule?
Yes, Your Honor.
Yes, Your Honor.
Court
Sir.
will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Anything you want to say before I impose sentence?
Just very briefly, Your Honor, Mr. Lee is asking that the court consider sentencing him to time served. I do acknowledge he wasn't arraigned on this case until September 19th and only has 9 days credit, albeit he was not being held on this case. Outside of that, I just leave it in the court's discretion.
Anything you want to say, Mr. Lane?
And I just wanted to get this over with and keep him going.
You come back on the other thing tomorrow. Is it tomorrow?
He's up on the 8th.
On the 8th.
For exam, Your Honor.
Just trying to recall, when I put you into custody, did we set an exam? Is that what we
Yes,
did
Sam is on the 8th.
before me?
No, it's before Judge Burke.
Okay. All right, I'll take a look at that because all right.
I think I have the file up, Aaron. Did the court have a question I could help with?
Well, I put him into custody, but I know I told him I was going to take a look at that on the remand into custody on it, because it came as a result of a police report regarding something else happening.
Yes, it was because there is a new case that is coming down the pipe, to which Ms. Blanche said that the warrant was going to be authorized that day, I believe. Mr. Lee advises, and I don't see anything to contradict that, he hasn't been arraigned on that new charge yet, however, but the two ones that he was in front of Your Honor for last week for PCC are set for exam, both cases in front of Judge Burke on October 8th. He's represented by Sam Bernstein in one and the public defenders in the other.
Okay, so my question becomes all right, that's right. That refreshes my memory. Where's that other case? Because the thing, I'm not asking.
Okay.
You don't know.
I know I ain't been arraigned on it.
No, I know, but I'm trying, because
So you're
I don't know, did I change his bond on? I did change his bond on that. He was supposed to then be arraigned on the other case, but that case was supposed to there was supposed to be a timing on that case to get down. So I remanded him. He was going to be held on these cases, on the ones that are set for exam. And then that other case was going to come down, expected that he might be in on that case. But if that case hasn't come down, I'm not going to be very happy right now.
Yes, to my understanding, Your Honor, he has not been arraigned on that new case, but the two cases that are already set for exam in front of Judge Burke, currently his bond is $15,000 on each of those cases.
Correct. I get that. What?
You raised it was a PR bond and you raised it up.
I put it up because of the representation of these other cases, but those other cases were what's the status of that other case?
Your Honor, Ashley Lottie, for the people on behalf of talking about these other matters. So if I'm reading this correctly, other cases was a resisting and obstructing case that was supposed to be coming down. Is that, Ms. Page, is that correct?
I don't think it was involving a car accident and some other stuff.
I don't know the exact charges that were to be authorized, but I know the incident date was before the ones that are currently set for exam.
Right.
That being said,
I know.
Yeah.
Listen, where is that case? Because my problem here is that, and Mr. Lee is certainly not always the most cooperative person in the world, and he knows that. But he got remanded because his other case was coming down.
Correct.
And so I'm trying to, and I think there was a representation that it had been signed off or it was someplace, and the expectation was that case was going to get sworn out. While in custody, he'd be arraigned. And then there would be, based upon the facts of that case, a bond set that was likely or may have, I can't say for sure, may have kept him in custody. Which is why I did what I did.
That was my understanding, Your Honor.
I just need a little bit more information.
Go, look.
So I wanted to understand, Mr. Lee was last before the court for PCCs. The court is saying on the 26th or the 18th.
I think it was a week ago, wasn't
I'm
it?
sorry.
I think it was,
The 20,
I think it was the 26th. He was before me.
I have some helping right now. So the new case, which does appear to be related to fleeing and eluding charges, dated incident 8/29/9/20 to 9/2. It appears that case was authorized, signed by my office on 9/26. And I don't see.
That's what was indicated to the court on the record, that it was signed off on 9/26. But then there was a representation that it was going to get sworn to. It was signed off by your office. I think that's what was represented to me. It was going to get sworn to so that Mr. Lee could be arraigned on it.
My understanding is that Magistrate Fink signed that case on September 30th. It is likely,
Well, then why hasn't he been arraigned?
I'm not sure, Your Honor. It may be in a stack of things that are waiting to be entered. That's been happening.
Oh,
I don't.
no, that will not happen. Miss,
Can you tell me what the jurisdiction is?
Yes.
It's not.
It's
not in.
Ypsilanti City. It's Ypsilanti City.
it's a city case?
No, I showed us.
It's a sheriff's office. It's a sheriff's office arrest that occurred in Ypsilanti City.
I show with the 14B.
Okay, so it's on the line. It said the swear out was on the 30th.
I have a police officer.
Oh, really?
Yes, that helps.
So, whoa. Is that what the log notes indicate?
Yes,
So there are no charges?
correct. It says court does not find probable cause.
Okay.
Okay,
Okay.
just hold. That's what it says?
Yes.
So there is no case?
Can I confirm the police report number for that?
Yeah, I have it all.
Washtenaw County Sheriff's Department report number 24-67821.
I have 68821. I don't know if that's a typo, but
And?
I'm checking with Melanie.
Yes, and while you're checking with them, have me bring them Mr. Lee's other two cases that are set for the 8th. Immediately. That's the last one I have. Now.
No.
Okay, Mr. Lee, that's
Yes.
what we're gonna do. I'm gonna have them take you back
Okay.
and we'll
All right.
try to figure everything out, have you brought back out, and I'll do what I gotta do.
Okay. Thank
All right?
thank you, Your Honor.
you.
All right. I'll see you in person soon.
Okay, thank you,
All
sir.
right. See ya.
Court recalls case people versus Don Lee.
Sir, is the court calling the felony matters or just
I am calling the felony manager also.
those matters?
Assistant Public Defender Natalie Pate with and on behalf of Mr. Lee, who stands to my right, please state your name again for the record, sir.
Don Lee.
And I'm calling so that we're clear, 24 FB 1322, as well as 224 F 1261.
It was 1322 and 24F21261.
The felony matters, yes, ma'am.
Thank you, Your Honor. Ashley Lottie for the people in both of those matters.
Assistant Public Defender Natalie Pate, with and on behalf of Mr. Lee, who stands to my right.
I still have to sentence him on the driving well or the operating well. So we've taken a look at it. That complaint that I put Mr. in custody on there was no probable cause found. And so that was not done. And I'm going to say this. They knew the reason. Mr. Lee understood what I was doing and putting me in custody. The prosecutor's office, I think, given the representation made to this court, was under an obligation to contact this court immediately upon notification that those charges were not brought, knowing that affected Mr. Lee's liberty. And I'm not happy that I wasn't contacted at all. Anything you want to say before I sentence him on his misdemeanor?
Nothing further, Your Honor. I would just reiterate his request to be sentenced to time served on that misdemeanor.
Fines and costs of $250. Those fines and costs are waived in their entirety. 90 days suspended on that case. With reference to his felony matters, those will continue to preliminary examination on October 8th before Judge Burke. Bond on those cases, both will be set at personal recovery.
Can you still use it on previous conditions that were in fact with
The conditions will remain. They never left.
Thank you.
It's just they took his liberty on something that didn't get authorized. You're going to be free to go, Mr. Lee.
I'm going home today.
You're going to be let out, sir.
Thank you.
Thank you very much, Your Honor.
Court's going to stand in recess.
All right. Thank you, Your Honor.
You're welcome.
Maybe seated. All rise. The 14th District Court for County of Washington, State of Michigan is now back in session. The Honorable Judge Jay said to preside.
Has the state prosecutor left?
I think so.
She needs to get back in here because I'm going back on the record on Mr. Lee. I don't know who else has that case. You may be seated, folks. Yes. At 1 o'clock?
Yeah, she has.
I want her here because I need a message gotten to that office right away. Court is recalling the cases of the people versus Don Lee, both his felonies and his misdemeanor cases.
Good morning again, Your Honor. Ashley Lonnie for the people.
Assistant Public Defender Natalie Pate on behalf of Mr. Lee.
I'm going to waive Mr. Lee's appearance because they took him down so he could be processed out immediately. But I want to make a record clear and know, and I realize, Ms. Lundy, you were not the one involved, but I am more than livid right now because this case, we went back and checked our records. Mr. Lee was taken into custody on the people's representation regarding the previous case. I took him into custody at 11:43 a.m. on June 26th. After having him wait here in court, I took him into custody on that date, and it's important, at 11:43 a.m. on the 26th. There was an attempt to swear out that case that was done before Magistrate Fink less than an hour later at 12:31 p.m., where the magistrate did not find probable cause. And this court was not informed. Mr. Lee was in custody. It was another attempt made to swear out that complaint on the 30th. Again, no probable cause. It is inexcusable that the prosecutor on their representations had this court act that deprived Mr. Lee of his liberty for 7 days. Inexcusable. So, Ms. Lundy, again, while you are not the person that was involved in this, but has done, I will expect a call from Ms. Burton Harris regarding this
Yes, Your Honor.
today.
Yes, Your Honor.
Thank you.
Thank you, Your Honor.
Are you kidding me?
Oh my God.
You have got to be kidding me. What is going on today? This is a joke. This is a joke. Today is a capitalist joke. We need an interpreter.
I need an interpreter when I cannot express myself sometimes.
Oh my God, sir, put that cigarette out. I don't give a crap that you are outside of this. What is wrong with everybody today? You know what, Miss Green, we're going to start bringing people in person. People going to learn how to act in a courtroom.
Can you hear it? Can you hear it? Ma'am? Ma'am? Can you hear it?
No.
Okay.
I have no taste for that. And trust me, after today, I'm sitting up here, I'm the one that needs a drink.